What is the basic structure doctrine? This doctrine states that the Constitution has a basic structure that cannot be altered or destroyed through amendments by the Parliament. The basic structure consists of the essential features of the Constitution that define the country as we know it. Normally, the Parliament has the power to alter or change parts of the Constitution, like the abrogation of Article 370 or various amendments made to many other articles. But thanks to the basic structure doctrine, some parts of the Constitution cannot be changed, such as democracy, federal structure, unity and integrity, secularism, socialism, social justice, judicial review, and rule of law. While the Constitution does not specify a basic structure anywhere, the concept evolved through the judgments in various landmark cases. In the Kesavananda Bharti case, the preamble was also identified as a part of the basic structure. Some of the other landmark cases are the Minerva Mills case, Vaman Rao case, the Indira Gandhi re-election case, the Indira Sahni case, and the S.R. Bommai case. What is the doctrine of separation of powers? This doctrine refers to the separation of powers and responsibilities of the government into distinct branches to prevent any one branch from gaining absolute power. The basic idea is that each branch of the government should have one main function. One branch should not unduly interfere with the others or exercise the functions assigned to any other branch of the government. In India, the powers and responsibilities of the government are separately entrusted to the legislative to make the laws, the judiciary to interpret the laws, and the executive to implement the laws. In addition, there are constitutional bodies such as the Election Commission for executing specific constitutional functions that are independent of the other three branches of the government. Article 50 of the Constitution addresses the separation of the judiciary from the executive, mandating that the state shall take steps to separate the judiciary from the executive in the public services of the state. In the Indira Nehru Gandhi versus Raj Narain case, the Supreme Court held that the separation of powers is part of the basic structure of the Constitution. What is the doctrine of pith and substance? Pith means the central idea or essence. Substance refers to the gist or the main idea. The doctrine of pith and substance involves looking at the true nature or meaning of a law to determine its constitutionality rather than just the words used. The doctrine is used when a law is challenged on the basis that one level of government has encroached upon the exclusive jurisdiction of the other. Article 246 divides power between the Union and the states. It classifies various subjects into three lists: Union, State, and Concurrent. Only the central government can make laws on subjects in the Union list, the state government can make laws on the state list, and both can legislate on the concurrent list. Now, liquor is in the state list, and if the central government passes a law banning the sale of fermented or distilled liquids containing alcohol across India, such a law may be challenged. While the specific words of the law may not mention anything about liquor, the court will look at the pith and substance of the law, that is, its true nature and what it seeks to ban, and will strike it down. What is the doctrine of severability? To sever means to divide by cutting or slicing, and here we are talking about dividing or cutting a law. The basic idea is that if there is a law or statute that mostly conforms with the constitutional framework, but some part of the law violates any fundamental rights, then that specific part can be severed from the rest. The court can declare the violative part to be invalid. If the remaining part of the law can exist and function even after the violative part is cut out, then the remaining part will continue to be valid. This doctrine is based on Article 13, which talks about laws that are inconsistent with or in derogation of the fundamental rights. The K. Gopalan versus State of Madras, State of Bombay versus F.N. Balsara, and RMDC versus Union of India were some landmark cases where this doctrine was used. What is the doctrine of eclipse? An eclipse happens when one celestial object is obscured or covered by another, such as when the moon obscures the sun and causes a solar eclipse. This doctrine is applicable when a law that existed before the Constitution is in conflict with the fundamental rights guaranteed after the Constitution was adopted. In such a scenario, the newly created fundamental rights obscured or overshadowed the old law. But the old law is not completely dead, it is just hidden. If the Constitution is amended to remove the conflict, then the old law will become valid again. This doctrine was most clearly articulated for the first time in the Bhikaji Narayan Dhakras versus State of Madhya Pradesh case in 1955. Remember, this doctrine is applicable on pre-constitutional laws only, and only if the old law violated any of the fundamental rights. Because fundamental rights are prospective and not retrospective, the pre-constitutional laws will remain valid on past transactions and also on non-citizens or those who are not covered under the fundamental rights. What is the doctrine of Laches? Laches means the failure to do something at the proper time. In the legal context, it refers to the negligence or unreasonable delay in pursuing a legal remedy, such as not enforcing a claim even when there was an opportunity to do so. While there is a similarity between this doctrine and the law of limitation, they are not the same. Limitation is applicable in specific situations after specific periods, whereas the Doctrine of Laches is applicable in situations which are not covered under the law of limitation. The courts can look into the specific circumstances and decide if the delay was unreasonable. In constitutional law, if there is an unreasonable delay in filing a writ, the court can dismiss the petition. Remember, the doctrine is applicable if there is a delay in initiating legal action, there is no reasonable reason for the delay, the law of limitation does not address the situation, and the delay, if condoned, will cause undue prejudice to the opposite party. What is the doctrine of territorial nexus? Nexus means a connection or a series of connections linking two or more things. Normally, the laws made by the parliament are applicable only in India, and the laws made by a state government are applicable only in that state. But thanks to the doctrine of territorial nexus, in some situations, an Indian law may be applicable outside India, and a state law may be applicable outside the state, if there is a connection or a nexus between the subject of the law and the territory where the law is normally applicable. For example, in the Tata Iron and Steel Limited versus the State of Bihar case, the Supreme Court held that the state government could levy taxes on sales outside the state, since there was a sufficient nexus between the subject and the territory of Bihar, by way of the goods being manufactured in Bihar. This doctrine is connected with and should be understood in the context of Articles 245 and 246 of the Constitution. What is the doctrine of casus omissus? Casus omissus simply means case omitted. That is, an issue or situation that has been left out of a statute, regulation, or a contract, which means that there is a gap in the law. This doctrine is used in the context of interpretation of statutes. Normally, the court should just interpret the law as is and not create a law. So, if the casus omissus is due to an oversight by the legislature, the court should not step in to supply the missing part. For example, if the law just says that wearing a helmet is compulsory, then any headgear that falls under the category of a helmet would meet the requirement. The court cannot step into the shoes of the legislature and decide what types of helmets are acceptable. It is up to the legislature to amend the Motor Vehicle Act to specify what protective gear is acceptable. The only exception where the court can step in to provide the missing part of the law would be if there is a very strong necessity and the reason for supplying the missing part is found in any other part of the statute itself. What is the doctrine of promissory estoppel? Think of the word stop when you hear estoppel. Estoppel is when a person is stopped from asserting or denying something that contradicts the person's own previous words or actions. While promissory estoppel in contract law is usually used to enforce oral contracts, it is applicable in written contracts also. A promissory estoppel prevents a promisor from denying the existence of a promise when the promisee reasonably relies on the previous words or actions of the promisor, and an injustice can be avoided only by the enforcement of the promise. For example, in the Motilal Padampat Sugar Mills case, the UP government had announced a 3-year sales tax exemption to promote new industries. The company started a new Vanaspati plant to take advantage of the tax exemption. Subsequently, the government decided to significantly reduce the benefits. Following the doctrine of promissory estoppel, the Supreme Court enforced the promise of a tax holiday. What is the doctrine of colourable legislation? Colourable refers to something appearing to be correct or justified, but in fact it is not so. The doctrine is based on the maxim, what cannot be done directly should also not be done indirectly. For example, in the K.C. Gajapati Narayan Deo case, the appellant challenged the Orissa Agricultural Income Tax Amendment Act, a state legislation, on the basis that it was indirectly levying income tax, which is a subject reserved for the central government. So, it is a colourable legislation. The respondents argued that the act levied tax on agricultural income, and agriculture is a state subject, so the law is not colourable. While clarifying on the concept of colourable legislation, the Supreme Court upheld the validity of the law, deciding that it was what it claimed to be, and it was not a colourable legislation.